Hey, Facebook Live. Sean Yesner here with Yesner Law, and I'm about to do another recording of an episode of the Crushing Debt podcast. And so I thought I'd bring you in behind the scenes of this recording. So this week, or this recording, I've been collecting stories of just dumb things, stupid things that banks and their attorneys have been doing. And so that's what this week's episode is going to be about. I think it's going to be fun. I think it's going to be funny. I'm going to peel back the curtain a little bit and give you some of the things that the banks are doing that are kind of stupid. So I hope you enjoy the episode. I'm just going to get my stuff set up here, and then we'll launch into the episode. On this week's episode of the Crushing Debt podcast, stupid things that banks do. So welcome back to this week's episode of the Crushing Debt podcast. My name is Sean Yesner with Yesner Law, and I wanted to do a podcast recording, like I said in the introduction, some of the dumb things that I'm encountering here as a foreclosure defense attorney. And so hopefully these stories are going to be funny. They are entirely true. Maybe in some cases, I've changed the names of the clients to protect the innocent, but I don't think the banks are innocent, so I'm not changing any bank names. So with that, we'll see how this goes. So the first story that I want to tell is about Wells Fargo. Now, Wells Fargo holds the distinction in my mind of being one of the worst servicers that's out there. But so here's what Wells Fargo did. We were negotiating a short sale with Wells Fargo, and we sent them too much. So the way that the settlement statement ended up being calculated, there was about $30 more than what the bank wanted. And, you know, whenever there's extra money in a short sale, the bank's instructions specifically say, send it to us. The bank's instructions specifically say, do not give it to anybody else. So we couldn't pad our attorney's fees by $30. We couldn't send the seller $30 or the buyer $30. That extra $30 had to go to the bank, had to go to Wells Fargo. Well, of course, what we did was when we initiated the wire, we sent them the wire inclusive of the $30. So I don't remember the exact payoff amount. Let's say it's $100,000. We sent Wells Fargo $100,030. Well, a couple days later, we got a call from Wells Fargo. Hey, we're about to kick back the wire. We said, well, why are you kicking back the wire? They said it's for the wrong amount. We said, well, we know it's for the wrong amount, but it's for the wrong amount too much. We sent you $30 too much. You're supposed to keep it. Your instructions say if we have any extra money in the deal, you have to keep the $30. Wells Fargo said, nope, we're kicking it back because the amount that you sent us doesn't match the amount that was on the payoff letter for the short sale, even though it was $30 too much. I said, well, can't you just send us the $30? They said, no, we can't send you the $30. We have to send you the entire wire back. And then once it goes into your bank account, you then need to wire it back to us without the $30 in the exact amount of what the instructions, what the payoff letter said. And so I said, well, what am I supposed to do with the $30? They said, well, we don't know what you're supposed to do with the $30. So, okay, fine. Sent the entire payoff back to us. We then reinitiated the wire, and we sent the wire off to Wells Fargo in the correct amount that matched their short sale approval letter without the $30 in it. Our escrow account then had an extra $30 in it. So I sent Wells Fargo a letter, and I said, on your instructions, I've sent you, the amount of money minus the $30. If you don't respond within the next, I think it was 7 days or 2 weeks or 14 calendar days or something like that, if you don't respond by such and such date, I'm going to send the $30 to the seller. I think it was belonged to the seller. Of course, never got a response. I'm sure that letter is still maybe winding its way through the halls of Wells Fargo somewhere. And this closing was years ago. And so never got a response from them. Actually waited double the amount of time that was in that letter that I sent to Wells Fargo, and then sent the seller their $30. So all of that back and forth, specific instructions that say, we want any extra money. And when they got the extra money, they sent it back to us. So nice job, Wells. So you didn't get the $30. You caused a whole bunch of time. You paid your employees to do a whole bunch of nonsense. But the payoff that you received matched your short sale approval letter. And so I guess now, especially given the way that things went down, even if someone from Wells Fargo is listening to this podcast, you're not getting the $30. I'm not going to tell you what client file it was anyway. So nice job. My next story is about an opposing counsel, an opposing attorney. And so what happened was I had a client who bought at the foreclosure sale of a homeowners association. Now, I've done a couple of podcast episodes and I've done a couple of blogs about why that's dangerous. And in this case, it was very dangerous because when she bought the property at the foreclosure sale of the homeowners association, there was also a first mortgage that was still there that needed to be paid off. So in the world of foreclosures and priority of liens and all that kind of stuff, the association is subordinate to the first mortgage. So when you buy at the foreclosure sale of the first mortgage, when you buy at the foreclosure sale of the homeowners association, if you want that property free and clear, you also have to negotiate with or pay off the first mortgage. Now, and that's why the client came to me. There were a couple of title issues that I needed to clean up, and then she wanted me to help her negotiate with the first mortgage. So we did some negotiation with the first mortgage, and my client ended up paying off the first mortgage in full. Now, typically when the homeowners association is in foreclosure, typically the bank, the first mortgage, even sometimes the second mortgage, are also in foreclosure. And that was the case here, is that the first mortgage was in foreclosure. And so when she paid off that loan, we had the foreclosure that we needed to stop. So the payoff was, I think, the beginning of the month, the beginning of January, actually, I think. And by the time we had sent the payoff to the bank, the payoff was the foreclosure sale was the end of January. So we had about 25 days or so, give or take, between the time we paid off the loan and the time of the foreclosure sale. So put a note in my calendar to make sure, since my client paid off the mortgage, she owns the house free and clear, that first mortgage should go away, that foreclosure should get dismissed. I get to the end of the month, to around the 20th of the month, and I look on the docket, and lo and behold, the foreclosure is still scheduled. The foreclosure is still there. And so call the bank's attorney, and I said, hey, we paid off the loan in full. Will you please cancel your foreclosure sale? Will you please dismiss your foreclosure lawsuit? Will you please, terminate, cancel, satisfy? Your loan has been paid off. Well, this property in this foreclosure was pending in Pinellas County. For those that don't know, Pinellas is Clearwater and St. Petersburg are the two biggest, probably best known cities in Pinellas County for those of you outside the Tampa Bay area. Well, one of the quirks of Pinellas County is that they require an affidavit when you want to cancel and reschedule a foreclosure sale. So the opposing counsel says to me, well, I need to get the affidavit signed by my client. I said, no, you don't need to get the affidavit signed by your client. The loan has been paid off. The loan no longer exists. You're not seeking to reschedule the foreclosure sale. You're seeking to cancel everything, satisfy everything, pay off everything. But she insisted that she needed the affidavit that Pinellas County requires in order to cancel the sale. And so I said, okay, look, I'll do it for you. I'll file the motion and I'll request that the judge cancel the sale. But if I do that, I'm going to ask for fees. And she said, why are you going to ask for fees? I said, well, because I'm doing your job for you. I'm filing a motion to cancel a foreclosure sale on a loan that's been paid off in full. The loan no longer exists. She said, well, I don't think the judge will grant you sanctions because, Pinellas County requires an affidavit. Okay, fine. So I gather up all the evidence that proves that my client paid off the loan, put it in I think it was a 2-page motion that basically said judgment was entered in the amount of X, payoff was received from the bank in the amount of X. Here's proof that my client paid the payoff before the due date in the amount of X. Plaintiff hasn't canceled the foreclosure sale yet. Judge, please cancel the foreclosure sale. I get it over to the court, I think 2 business days before the foreclosure sale. The next day, the order comes back from the judge, and of course the sale is canceled. Now, when I sent the order over to the judge, I said something in the order that said that I was entitled to fees or not entitled to fees. And if I was entitled to fees, it was going to be in the amount of blank as sanctions. So, of course, the judge said, yeah, you're approved for fees, and then the amount to be determined. Now, as of this recording, I haven't had the hearing yet on my fees, but the judge said I was entitled to fees basically for doing the plaintiff's job for them. I get a call from the bank's attorney, and the bank's attorney says, well, what happened at the hearing? And I said, there was no hearing. The judge reviewed our motion. The judge saw everything in the motion, and the judge decided that the sale should be canceled and that I should get fees for doing your job for you. So I then said to the opposing attorney, hey, let me know. I'm not a bad guy. I'm not going to beat you over the head about this. Let me know. Let's, settle up with the fees. I'll be, professional courtesy and whatnot. I'm not going to crush you for thousands of dollars in fees. Pay me a couple of $100 for doing the motion. At that point, she said, well, I have to check with my client. I said, well, actually, your client's probably going to be mad at your firm for allowing this to happen. So if you guys just want to pay me a couple of $100 and we're done. She didn't want to do that. And so after I calculated my time, my assistant's time in generating the motion, filing the motion, following up with the judge, following up to make sure the sale's canceled, following up with all that stuff, I think it came out to $1,000, give or take, in fees and time and whatnot. And so that's what I'm requesting from the judge. So, we'll see what the judge does. Now, postscript to that, all of that, instead of satisfying this first mortgage that was paid off, the bank's attorney has now filed a motion to unwind the entire foreclosure and get the original note and mortgage back. Now, I don't know why they would do that. The loan has been satisfied, but rather than continuing to beat up on this poor opposing attorney for making incorrect conclusions of law, I think I'm just going to wait for my hearing, which is coming up in a month, see if I can get some fees out of them. I've also sent emails to the law firm that said, hey guys, someone in the law firm, give me a call. Let's work this out. Some senior attorney, give me a call and let's work this out. And to date, I haven't received anything from them. So, guys, just sort of think, if the opposing counsel had just used her knowledge, her common sense a little bit, a lot of this could have been avoided. And, I would have settled the case, or we would have gotten it canceled or whatever. But now we're in the position that I'm probably going to make a nice little bonus check here based on the mistakes of the opposing attorney, even though I gave them ample opportunities to fix it. So I do want to take a little break. I got two more stories here that I want to tell you, but I do want to take a little break. So as you heard in last week's episode, the Crushing Debt podcast now has a sponsor. And so interestingly, in this case that I was just describing, where my client bought at the homeowner association foreclosure sale, a lot of times investors that buy property need to have life insurance to cover if something happens to them, what happens to their property. So I want you all to go to elliottwealth.com and visit their website. That's the website for Elliott Wealth Management Services. So for my listeners only, they are offering a 15-minute life insurance checkup. If you go to the website, which is elliottwealth.com, you'll find a life button at the top of the page. Click that button and you'll get your free 15-minute life insurance checkup. Elliott Wealth Management is a comprehensive financial planning firm committed to helping its clients win with money. And so there's all kinds of reasons. We went through it in last week's episode, why you should have life insurance, how life insurance can help if you have a lot of debt, if you invest in real estate, changes in marital status, if you're having kids, if you have your own business, if you have people that rely on your income, you should do a life insurance checkup. Elliott Wealth Financial provides 100% independent advice. They represent dozens of the best insurance companies out there. And again, they're offering all of you, my listeners, a complimentary 15-minute life insurance checkup to make sure your loved ones are protected. You can go to elliottwealth.com, hit the life button at the top of the page. That'll get you your free 15-minute life insurance assessment. So thank you to Elliott Wealth. Thank you to Chris Calandra and all the guys over at Elliott Wealth for their support of the podcast. So back to the stories here. I've got two more to tell you, and then I think that will put a wrap on this week's episode. So I had I've been dealing a lot with Deutsche Bank, and I want to keep this episode not explicit. I want to keep this episode clean, and so I won't tell you what people call Deutsche Bank. But I had a case once where all the client wanted was a little bit more time to move out of the house. And so he did. He ended up getting the time that he needed. He ended up moving out of the house. And once he was out of the house, he said, I'm done with it. Don't worry about delaying the foreclosure. Don't worry about fighting the bank. Don't worry about doing anything. Once I'm out of the house, I'm out of the house. I'm done with it. I don't care about it. I don't want it. I don't care about the consequences. Let the house go. Okay, fine. So we get to that point in the litigation. The client moves out. I call the bank and I say, listen, we'll agree to the foreclosure. I'm not even going to ask you to give me an extended sale date. So in other words, on the day we have our final hearing with the judge, the foreclosure sale can be 30 days later. We don't care. Go for it. Take the house back. We don't want it anymore. So the judgment gets entered. The foreclosure sale gets scheduled. A couple days before the foreclosure sale, I get a motion show up in my email filed electronically by the bank. The bank canceled the foreclosure sale to say because they said the client wanted to do a loan modification. And so I called the client and I said, hey, the bank's stopping the sale because they're saying you want to do a loan modification. Is that true? He said, no, I still don't want the house. I don't want to do a loan modification. It doesn't matter what they modify. I'm never going to keep this house. I don't want the loan modification. So here we go. The bank files to stop a sale because they say the borrower wants to do a loan modification on a case where the borrower doesn't want to do a loan modification. They just stopped the sale because they wanted to stop the sale. I think maybe the house may have had some damage to it. And so instead of saying, hey, we want to stop the sale because the house has damage and we want to assess the house, the bank just flat out lied and said we want to do a loan modification review. And the client said, I don't want to keep the house. I don't want to do a loan modification. So another couple of months went by, and then the bank ended up filing the documents and ended up proceeding with the foreclosure sale on the house that my client wanted to get rid of in the first place. So I think the only thing that would have made that better is if I had maybe like filed a bankruptcy or something to continue to delay it unnecessarily in this case, since he doesn't want it anymore. But in this one, hey, bank filed to stop it on their own. We had absolutely nothing to do with it. So, and in fact, we didn't want it, but the bank decided to stop the foreclosure sale anyway. And I get the feeling that happens more often than not, that they stop the foreclosure sale when maybe the borrower doesn't want them to. And this was a situation where the borrower was single. So there was no wife that wanted to keep the house. There were no kids that wanted to keep the house, no parents that wanted to keep the house. Single guy lived in the house, got the time he needed to get out and find a new place to live, and then said, let the house go. And the bank refused to do it. The last one I want to talk about actually spawned another podcast episode of a rant that I went on about loan modifications and foreclosure mediations. So if you go back a couple of episodes, you'll find a podcast episode. Let me see if I can find it here. It would be an episode that I was really upset about what this particular bank did, but it was such a dumb story that I decided to include it in this episode. Yeah, so if you go back to episode 129, the title of episode 129 is Foreclosure Mediations Are a Waste of Time. That entire episode was inspired by the story that I'm about to tell. So I had a situation where I was representing a wife in foreclosure. Now, the husband had filed bankruptcy previously, and it is allowed in bankruptcy court if a couple is married for the husband to file without the wife, or the wife to file without the husband. One spouse can file bankruptcy without the other, and that happened in this case. The husband filed bankruptcy without the wife. At some point, the wife came to me and said, but I want to keep my house. And so what do I do to keep the house? And so another episode that I've done previously, I talked about a case out of the 11th Circuit up in Atlanta where they said, if in bankruptcy court, you surrender your house. So if you file a document in the bankruptcy with your bankruptcy petition that says, I don't want to keep my house, then you can't go back to state court and fight to keep the foreclosure. You have to basically allow the bank to foreclose if that's what you represent in your bankruptcy documents. And so in looking at the situation, the husband was the one that filed, not the wife. So I didn't think that that case applied to the wife because the wife didn't file bankruptcy. So I start defending the foreclosure. I submitted my motion. I asked for more time to respond to the lawsuit. I filed a motion for mediation. I filed all of this stuff without objection from the bank. We get to the mediation, and of course, it's Ocwen, if I can say the name of the bank, it's Ocwen. Ocwen says to me at the first mediation, well, you send us, 100 pages of documents and we're missing the middle 2 pages, but we got all the ones before it and all the ones after it. Okay, fine. So let's continue the mediation to another date. Okay, fine. So we continue the mediation. We send the entire package again. I think there was one thing they were missing from the husband's bankruptcy attorney to allow us to try to mediate and modify this loan. We get that document from the husband's bankruptcy attorney. We send that in. We go back to the second mediation. We still don't have the documents that we need. Fine, we extend it. We go to the third mediation. Now, again, there's months between these mediations. We send the entire package in again, including the information from the bankruptcy attorney for the husband that says, yes, you're free to modify. We're okay with you modifying for the wife to keep this house. I think they were getting separated. We go through the whole process again. We get to the fourth mediation. The fourth mediation, I think we're a year later now. We get to the fourth mediation, and we all sit down at mediation, and Ocwen says their policy is not to modify loans when one of the borrowers is in bankruptcy. Well, you couldn't have told us that a year earlier when we were filling out all these modification forms, number one. Number two, I know that's not true because I've modified loans with Ocwen when borrowers were in bankruptcy. I've done it before. So I know that the person on the other line is just lying to me about Ocwen's policy about not modifying loans that are in bankruptcy. So I end up going on this rant, the previous episode that I talk about how foreclosure mediations are a waste of time. We then end up getting the case settled. We end up agreeing with Ocwen, we're going to settle the case. I say, okay, send me the settlement agreement. They send me the settlement agreement, and in the settlement agreement, it says, Ocwen offered loss mitigation options, loss mitigation meaning mediation, modification, that kind of stuff, and the borrower refused the loss mitigation options. Well, of course, those two issues are false and flipped. Ocwen offered no loss mitigation options. In fact, Ocwen said it's their policy that they don't modify loans when they're in bankruptcy. And even when I tried to nail down opposing counsel to where is that policy written, how is that policy, how often is that policy enforced, when was the last time they did modify a loan in bankruptcy, he wouldn't answer me because he knew his own client was lying. And then the borrower refused loss mitigation options. No, absolutely the reverse. We wanted to save the house. So I thought it was funny that at the mediation, Ocwen says our policy is not to modify loans in bankruptcy, but then when they give us the settlement, it says, we've offered you loss mitigation options. No, you haven't. You just got in a case where your representative maybe was lazy or didn't understand the law. And of course, attorneys these days for the banks are no longer counselors. They're just, hired guns with the blinders that do what they're supposed to do. And I have a respect for all these guys. I know a lot of the plaintiffs' attorneys. They're all good guys, but gone are the days when they can actually give advice and counsel to their clients. And so they got to do what they got to do. I got to do what I got to do. But in the meantime, the bank is going to continue to make dumb decisions. The banks are going to continue to do stupid things. I'll be here to document them all. Maybe I'll do another episode here of the podcast where I talk about more dumb things that banks have done over the course of my career. I only told 4 stories, but I think there are absolutely more of them. So with that, I think I'm going to put an end to this week's episode of the Crushing Debt Podcast. If you've got some dumb stories about what the banks have done, share them with me. My email is Shawn, SHAWN, at Yesner YESNER law.com. Share those dumb stories with me. Tell me things that the banks have done that just drive you crazy, that make no common sense. And of course, if you need help with any of these topics, give me a call. We can do a free consultation. Also, go ahead and give our sponsor, Elliott Wealth Financial, some love. Go to elliottwealth.com, ELLIOTTWEALTH.com. Click on the button in the corner, in the top of the page there, where you can do your 15-minute free life insurance checkup. That is all for this week's episode, and we look forward to talking to you in next week's episode of the Crushing Debt Podcast. So, Facebook Live, I am back. Just finished recording. I am going to export this so that we can get it engineered here to be released, probably coming out sometime in late April, early May. So let me just get that saving here for you. That'll be a podcast episode, and then once it goes up on the podcast, I'll probably shoot it up to YouTube. But there's a couple people on Facebook Live. So if any of you have comments you want me to answer, you got some free legal here. If you want me to hang out for a little bit and answer some legal questions, go ahead and post them. I did see that Jim Jenkins, who has been a guest on the show, on the podcast as well, Jim chimed in about the first story I told about the Wells Fargo not wanting the $30. Yeah, sorry, Jim, I'd give it to you, or we'd take it and go have some adult beverages, but that money was gone to Wells Fargo a long, long time ago. Scott Provost, hey, how you doing, buddy? Mike Sullivan, I'm not going to respond to your comment, Mike. I'm just not going to engage. Other than that, if anybody else has any questions, go ahead and post them in the comments. I'll answer your questions online to the extent I can. To the extent I can't, I know I've got a legal network of attorneys that can help resolve your issue for you. While I'm doing that, I'm going to put my office back together so that I can get out of here when I'm done recording. And because I see no messages on Facebook Live, I am going to assume that you guys don't have any questions for me. And so I appreciate you all listening. I appreciate you all subscribing to the podcast. The numbers are increasing exponentially. I think I had 1,000 more downloads last month or this month than I had last month. And so I really appreciate all the support and listeners and all that stuff. If you have questions that you want me to answer on the podcast, please. I'm always looking for content. I'm always looking for ways to continue to educate. Yes, sir, Eric. It is Beer 30. And tonight is First Friday in West Chase. So any of you local here in Tampa Bay, head out to West Chase. Catch me. I may or may not change out of this shirt. If I do change out of this shirt, I'll probably be in some kind of podcaster or Yesner Law or whatever shirt. So, yeah, come catch me at First Friday. I think all the Yesners are going to be out at First Friday for Beer 30. I can't do Beer 30 right at this moment. My oldest is in the conference room wrapping up some client consultations. And so I don't want to do Beer 30 and then drive him home. But as soon as I am at a point where I have my designated driver wife with me, it will absolutely be Beer 30. Having received no other comments and trying to stall time until then, I think I'm going to wrap up this Facebook Live. Thank you all for watching. Thank you all for your support. And I will catch you next time I record a podcast episode.